Section 6 of TPA. What may be transferred? Actually, this section we have what may not be transferred. It's just named and highlighted positively. Property of any kind may be transferred except as otherwise provided by this act or by any other law for the time being in force. TPA is generally an act which is mentioning in itself that it can be overridden by any other law which is and which might be in the force in future. It can be suppressed. This law can be suppressed or pressed by other law which is in force. Suppose, suppose the chance of an heir or parent succeeding to an estate, chances of relation obtaining a legacy on the death of kinsman or other mere possibility of like nature cannot be transferred. This means the heir who is getting the property, the right, the bundle of rights, the right to transfer, right to enjoy possession and other titulary rights, it cannot be transferred on the basis that I'll get them in future, or anyone who's getting the property that after the death of kinsman on just a mere possibility can sell it in future. It can't be transferred in this such possibility. A mere right to re-entry for breach of a condition subsequent cannot be transferred to anyone except the owner of the property affected thereby. Let me explain to you the meaning of condition subsequent. The condition subsequent means this is the condition in which the proper transfer of property is already been done, and there are certain terms which are being followed and being practiced. The breach of these terms and conditions which are given by the transferor to the transferee, if they are breached, the transferor have right a mere right to re-entry into the property, and this mere right to re-entry in the property can't be transferred. It cannot be transferred at as it's totally contingent on the nature of waggery, so it cannot be transferred. C. An easement cannot be transferred apart from dominant heritage. An easement and dormant heritage is a concept in which, suppose there is an area, let me explain it in more expressive way. Assume this is a plot of land, and this is another plot of land, and A owns a assume a one two three four a pentagon here. So this whole area doesn't belong to A. It belongs to B. This is road, and while anyone wants to reach in A's area, let me mark A here to avoid confusion. So what we need is the way here to this area. So A will get an way like this to connect this plot to the road. This is a dominant heritage and this is easement. So the A can't use this land for anything but just for passage. This is called easement. And mere right of easement cannot be transferred alone. Like he cannot sell the right, he can't sell the right that you can go from here and here without selling right of this dominant heritage. They are the right of easement are dependent on the right of owning this dominant heritage. C. An easement cannot be transferred apart from dominant heritage. D. An interest in property restricted in its enjoyment to owner personally cannot be transferred by him. Like if the property is given to the owner only to enjoy the position and not all the bundle of rights are being given to him. Only mere right to enjoy the position is given to him. It cannot be transferred by him. Example that I have given my property to my relative to stay. He's mere a licensee. He can't use it and transfer the rights of only use it. He can't be transferred. The property can't be transferred as a licensee. A right to future maintenance in whatsoever manner arising secured or determined cannot be transferred. Right to future maintenance cannot be transferred as stated in the statute. A mere right to sue cannot be transferred. No one can transfer mere right to sue. The one who have a cause of action could only sue. The cause of action could cannot be transferred. Like that A and B got into a contract and B breached the contract. So A cannot transfer the right to sue that to C that you can sue A B for the breach. The breach can't be sued. A have to fight here his right to by himself only. Public officer cannot be transferred. Office a public office cannot be transferred, nor can the salary of a public officer, whether before or after it has become payable. A public office, that the office of president, prime minister, even a judge is a public office, and every other office like an IAS, and a person after becoming an IAS can't make an offer into society that you can buy me post in my office and I can transfer my post to anyone. So it can't be transferred, nor that a public officer can contract anyone that the salary of my whole life is yours, or it could be directly be available to you. It can't be transferred. It is not like that. G. Stipend allowed to military, naval, air forces, and civil pensioners of government and political pensions cannot be transferred. Same reason is F. No transfer can be made so far as it is opposed to the nature of the interest affected hereby, thereby, or two, for the unlawful object of consideration within the meaning of the Section 23 of Indian Contract Act 1872, the person legally disqualified to be transferred. In this section stated that if a transfer is unlawful on the terms of contract which is given in 23, which refer to illegal illegality of or unlawfulness of consideration. Every contract is void under section 25 of ICA if the consideration is not there and a valid consideration is not there. Unlawful consideration means that A will transfer property in the name of B if he kills C. That's totally unlawful object, and law does not promote lawfulness and illegal activities. That's why clause H is mentioned here. I. Nothing in section shall be deemed to authorize a tenant having an untransferable right of occupancy the former of an estate in respect to which debt has been made in paying revenue or lease of an estate under the management of court of wards to assign his interest as such tenant, farmer or lease. The same conditions mentioned but in different form, which are mentioned in subclause D. The property given to enjoy the possessory right, the right of possession, cannot be transferred by a tenant. That's a point. In section number 6, subsection A, the clause A is mentioned with the word here apparent succeeding to an state. What is this? It is spec succesionis. What is spec succesionis? While defining spec succesionis, we'll state that it means expectation. It means expectations of succession, of having a chance of getting the property through succession. It is not present property in Collar versus Isaac 1881. Court explained that rationale behind the provision to the effect that person cannot assign to another what is not in existence. It is a mere possibility of getting certain properties in future. Spec actionis is based on property, on public policy. If such transfer are allowed, that would lead to increase in the public litigation because what you cannot own, you cannot transfer it. There is a famous maxim for it, which I don't remember right now. The chances of an heir apparent succeeding to an estate or the chances of the relation obtaining a legacy of death of kinsman or other mere possibilities of like nature are not able to transfer the property. Heir apparent is apparently an heir but not a legal heir. It is an English term based on maxim nemo esri viventis, which means a living person does not have any heir. If person is an heir apparent, then it means it would be an heir in future. If he survives the propositus and propositus dies interstate, for example, as between father and son, both are entitled to the property of another. If the father dies first, the son becomes the heir and he inherits the property. But if the son dies first, he cannot inherit father's property. Now the question of who will die first and who will that's completely a question of wager, and wager is not allowed it. Therefore, during the life of father, son cannot be called heir. He is mere heir apparent. He is only the person who appears to be a heir, and he just have chances of getting a legacy. And this type of transfer are completely void ab initio. What does mere right to sue? I've explained it in section 6 clause E. Under section 6, right to sue means the sue of uncertain sum of money. Claim for uncertain sum of money arises when it is claimed for unliquidated damages. When the damages are unliquidated, that we cannot certain the damages are ascertained, uncertainable. For example, A acts negligently towards B. Now B gets a right to sue A for damages, but instead of suing A, he assigns the right to C. C sues A claiming damages for negligence. The transfer of rights to sue is void. The word used, mere, is important. It includes and indicates the bare right to sue devoid of any interest or property of some transfer. I've explained it in examples. That's completely true. Thank you for watching this video.